The marble columns of the Supreme Court rose majestically as morning light filtered through the high windows. The highest court in the land was hearing arguments in Wilson versus Educational Opportunity Foundation, a complex case involving equal access to educational resources across different communities. Legal experts had anticipated a routine, if crucial, day of technical arguments about funding formulas and jurisdictional questions. Chief Justice John Roberts presided with his characteristic calm authority. At 70, the veteran jurist had heard thousands of oral arguments during his tenure on the court. His penetrating questions and exact legal mind had earned regard across the ideological spectrum, even from those who often disagreed with his conclusions. Representative Jasmine Crockett, a former civil rights attorney before entering Congress, had filed an amicus brief in the case and was granted time to present oral arguments. Though respected in legal circles, few expected her presentation to stand out among them, any distinguished attorneys appearing that day. What happened next left the entire courtroom in an instance of crucial silence. As Crockett concluded her meticulously crafted presentation about educational equity and legal constitutional values, Chief Justice Roberts leaned forward slightly. Instead of moving immediately to questions as expected, he did something extraordinarily rare in the formal setting of the Supreme Court. Representative Crockett, he began, his voice carrying clearly through the hushed chamber. Before we proceed to questions, I want to recognize something. In my years on this court, I have seldom encountered legal logic that so precisely weaves together legal constitutional values, precedent, and practical realities. Your presentation today represents legal representation at its finest. The sincerity in his voice was unmistakable. This wasn't perfunctory courtesy, but genuine expert regard. From the nation's highest legal officer to an advocate whose legal brilliance surpassed the usual partisan divides, the entire courtroom fell into a reverent silence that recognized the notable nature of this instance. Before we continue this exceptional story, please take an instant to like this video and subscribe to our channel for more content that celebrates moments when legal quality and expert regard rise above our partisan differences. To understand why this instance between Chief Justice Roberts and Representative Crockett resonated so deeply in legal circles and beyond, it's crucial to appreciate the unique journeys and legal backgrounds of these two accomplished attorneys. John Roberts had followed a path of consistent legal quality throughout his career. After graduating from Harvard Law School, where he served as managing editor of the Harvard Law Review, he clerked for then Associate Justice William Rehnquist. His subsequent career included distinguished service in the Department of Justice and private practice, where he argued 39 cases before the Supreme Court prior to his appointment to the bench. Nominated as Chief Justice in 2005, Roberts had developed a standing for thorough jurisprudence that respected precedent while remaining open to evolving legal understanding. Though generally conservative in his legal philosophy, he had occasionally surprised observers with decisions that crossed ideological lines when he believed legal constitutional values required it. Legal scholars who studied Roberts' tenure noted his deep commitment to the integrity of the court as an institution above partisan politics. A former clerk once observed, "The chief believes profoundly in Therrell of the court as an impartial arbiter of legal constitutional values rather than a vehicle for partisan preferences. That belief shapes everything about his method to the law." Roberts was known for holding attorneys to exacting standards during oral arguments, posing exact questions that tested the logical foundations of their positions. His regard was not easily earned, making his recognition of exceptional legal logic all the more crucial when it occurred. Jasmine Crockett had traveled a different path to legal prominence. After graduating from law school, she had built her career representing clients from underserved communities in civil rights and educational access cases. Rather than the prestigious corporate firms that often serve as pipelines to legal appointments, she had chosen to work directly with those most affected by systemic inequities in the legal system. This frontline experience had given Crockett an unusual perspective on how abstract legal values translated into real impacts on communities and individuals. Her method to legal constitutional interpretation was informed not just by theory, but by direct observation of how legal decisions affected people's lives and opportunities. After establishing herself as a formidable civil rights attorney with several landmark cases to her credit, Crockett had successfully run for Congress, where she quickly distinguished herself through her substantive method to legislation, Unlike many representatives with legal backgrounds who set aside deep legal evaluation for partisan messaging, she continued to engage with complex legal questions, bringing her litigation experience to her legislative work. The Wilson case that brought Roberts and Crockett into the same courtroom centered on whether funding disparities between school districts violated legal constitutional equal protection guarantees. The case raised complex questions about the intersection of local control, federal authority, and core rights, issues that had divided courts for decades. We'd love to hear in the comments section if you've ever witnessed an instance where expert quality was recognized across usual dividing lines. These moments of genuine regard remind us that expertise and integrity can still transcend our partisan differences. The Supreme Court that morning was filled with the usual array of justices, clerks, attorneys, journalists, and fortunate members of the public who had secured coveted seats. The atmosphere was one of formal attentiveness, with the court's traditional decorum creating a setting where legal arguments took center stage, separated from the more theatrical aspects of partisan discourse. What no one anticipated was that this session would produce an instance of expert recognition that would soon inspire discussions about legal quality and regard across the entire legal community. The Supreme Court session had begun with the usual formalities. The marshal's announcement, the justices taking their seats, preliminary matters addressed efficiently. Before oral arguments began, the first attorney, representing the petitioners, had offered competent arguments about local control and traditional funding mechanisms, facing pointed questions from justices across the ideological spectrum. When Representative Crockett's turn came, those familiar with Supreme Court proceedings noticed subtle differences in her method that immediately distinguished her presentation. Rather than beginning with abstract legal values or partisan framing, she opened with the exact articulation of the legal constitutional question at hand. "Mr. Chief Justice, and may it please the court," she began, "this case presents a core question about how we interpret equal protection, guarantees when educational opportunity, a cornerstone of meaningful citizenship in our republic, varies dramatically based on community resources and local tax bases." From this opening, Crockett moved into a methodical evaluation that showed unusual legal precision. Rather than arguing from broad values alone, she wove together several strands of legal logic that built her case layer by layer. First, she traced the evolution of equal protection jurisprudence through key Supreme Court decisions, demonstrating how the court's understanding had developed over decades. Unlike many attorneys who selectively cite favorable precedents while ignoring contrary ones, Crockett directly addressed cases that might seem to undermine her position, distinguishing them with nuanced evaluation rather than dismissive characterizations. In San Antonio versus Rodriguez, this court held that education is not a core right explicitly guaranteed by the Constitution, she recognized, referencing a case often cited against educational equity claims. However, the court's subsequent jurisprudence in Plyer v. 2 recognized education's unique value in upholding the fabric of our society and enabling meaningful participation in civic life. This direct engagement with demanding precedent caught the attention of several justices who leaned forwards lightly, the Supreme Court equivalent of showing keen interest. Crockett then moved to her second analytical strand, examining how the court's method to equal protection had evolved, beyond formal equality to recognize substantive dimensions of legal constitutional guarantees. She cited with exact specificity language from opinions written by justices across the ideological spectrum, demonstrating how this understanding had developed through diverse legal perspectives. Justice Elena Kagan posed the first question, probing the boundaries of Crockett's legal theory. "Counselor, if we accept your framework for analyzing these educational disparities, what limiting principle would prevent similar claims regarding other public services where local funding creates disparities?" It was the kind of demanding question that often disrupts an advocate's presentation, forcing them to either concede weaknesses in their position or retreat to vaguer values. Crockett's reply, however, showed the depth of her legal thinking. Justice Kagan, the limiting principle, emerges from this court's consistent recognition of education's unique position in enabling meaningful exercise of other legal constitutional rights and civic participation, she began. She then articulated a three-part test derived from the court's own precedents that would distinguish educational equity claims from those involving other public services, providing a practical framework for legal evaluation. that respected separation of powers concerns. Justice Samuel Alito followed with a question from a different perspective. Your presentation seems to require crucial legal oversight of local educational funding decisions. How do you reconcile this with our federalism values and tradition of local control in education? Again, Crockett's reply reflected deep legal understanding rather than ideological positioning. Justice Alito, federalism serves legal constitutional values by protecting both state authority and core national rights. The framework I'm proposing respects local control for most educational decisions, while recognizing that extreme disparities that undermine equal protection guarantees properly invoke federal legal review. She continued by citing specific examples from states where local control coexisted with legal constitutional equity guarantees, demonstrating that her position built upon rather than discarded federalism values. This nuanced reply, acknowledging legitimate concerns while providing substantive answers, clearly impressed even justices likely to be skeptical of her ultimate conclusions. As her presentation continued, Crockett introduced her third analytical strand: empirical evidence connecting educational resources to meaningful outcomes. Unlike many attorneys who rely on generalized assertions about policy impacts, she offered specific research findings with methodological context that anticipated potential criticisms. The empirical evidence confirms what this court recognized in Brown v. Board of Education, that education is a right, which must be made available to all on equal terms if equal. Protection guarantees are to have substance rather than mere form. Recent longitudinal studies using causal research designs demonstrate that systematic resource disparities create precisely the kind of arbitrary disadvantage based on circumstances of birth that the Equal Protection Clause was designed to prevent. Chief Justice Roberts, who had been listening intently throughout, posed what many considered the most demanding question. Representative Crockett, your presentation requires us to make comparative judgments about educational adequacy across different contexts. Doesn't this inevitably draw courts into educational policy decisions better left to legislative bodies? This question went to the heart of the separation of powers concerns that often guide Roberts' jurisprudence. The courtroom grew especially attentive, recognizing this as a potential turning point in the presentation. Crockett's reply showed both deep regard for the court's organizational role and exact understanding of legal constitutional values. Mr. Chief Justice, theme that I'm advocating recognizes the primary role of legislative bodies in educational policy, while preserving the judiciary's vital function in enforcing legal constitutional guarantees. She continued with notable specificity. The test I've outlined would not require courts to make policy determinations about optimal educational methods or specific funding levels. Rather, it would examine whether disparities are so severe that they effectively deny some children the basic educational opportunity that enables meaningful exercise of other legal constitutional rights and civic participation. Crockett then connected this framework to the court's own organizational history. This method builds upon this court's long-standing practice of identifying legal constitutional floors without mandating policy ceilings, preserving legislative discretion while enforcing core guarantees. Throughout her presentation, what distinguished Crockett's representation was her ability to engage with demanding questions as opportunities for deeper evaluation rather than obstacles to avoid. Each reply built upon her core legal framework, while demonstrating regard for legitimate organizational concerns raised by the justices. As she concluded her formal presentation, Crockett returned to first values. The Constitution's promise of equal protection requires that where states choose to provide education, which all 50 do, they cannot do so in ways that systematically advantage some children and disadvantage others based merely on the arbitrary circumstance of which local community they live in. This court has the legal constitutional authority and responsibility to enforce that guarantee while respecting the proper role of legislative bodies in shaping specific policies. Her final words reflected both conviction about legal constitutional values and regard for the court's organizational role. The framework I've offered offers a path for the court to fulfill its vital function as guardian of legal constitutional guarantees while preserving appropriate deference to legislative judgments about educational policy. It is rooted in this court's own jurisprudence, respectful of federalism values and faithful to the Constitution's core promise of equal protection under law. As Crockett finished, the courtroom remained in that rare state of complete attention that signals exceptional representation. Even attorneys waiting for later cases, who often use oral arguments to prepare their own presentations, had set aside their notes to follow her evaluation. It was at this instance that Chief Justice Roberts, instead of moving immediately to the next scheduled presenter, offered his unprecedented acknowledgement of her legal brilliance, an instance of genuine expert regard that surpassed the partisan differences typically associated with educational equity cases. Representative Crockett, Chief Justice Roberts began. Before we proceed to questions, I want to recognize something. In my years on this court, I've seldom encountered legal logic that so precisely weaves together legal constitutional values, precedent, and practical realities. Your presentation today represents legal representation at its finest. The courtroom fell silent. Those familiar with Supreme Court proceedings understood how exceptional this instance was. While justices occasionally praise particularly strong representation, such recognition from the Chief Justice, especially one as balanced and exact as Roberts, represented the highest form of expert regard in the legal community. Roberts continued, his tone reflecting genuine expert appreciation rather than perfunctory courtesy. Your ability to anticipate and substantively address organizational concerns while upholding a coherent, legal constitutional framework demonstrates the kind of rigorous legal thinking that assists this court in its deliberations, regardless of where individual justices may ultimately come down on the merits. This wasn't empty praise, but specific recognition of the qualities that distinguish truly exceptional legal representation, anticipating concerns, addressing them substantively, and upholding analytical coherence throughout. It was praised for intellectual integrity and legal craft, not for reaching a particular conclusion. Justice Sonia Sotomayor, who had yet to ask a question, nodded in visible agreement with Roberts's assessment. Though often at opposite ends of legal philosophy from the Chief Justice, she recognized, as he did, the exceptional quality of Crockett's legal logic. Roberts concluded his unforeseen comments with an observation that captured why this instance would soon resonate throughout the legal community. Representation of this caliber elevates our entire legal system by demonstrating how ethical logic can address even the most complex and contested legal constitutional questions. It reminds us that at its best, legal presentation is not about partisan positions but about faithful interpretation of legal constitutional values. The silence that followed wasn't the awkward pause of surprise confusion, but the reverent steady of collective recognition, an acknowledgement that those present had witnessed something exceptional in the life of the court. Journalists present, even those who typically emphasize partisan differences on the court, recognize that this instance surpassed usual ideological narratives about Supreme Court proceedings. As the silence stretched for several seconds, Crockett responded with expert grace that matched the instance. Thank you, Mr. Chief Justice. The opportunity to present complex legal constitutional questions to this court is the highest privilege of our profession. I'm deeply honored by your words. The exchange, brief but crucial, captured something vital about legal quality that often gets lost in partisan coverage of the court. Beyond ideological differences and policy disagreements, there exists a shared appreciation among legal professionals for exceptional analytical logic and ethical representation. Justice Stephen Breyer, known for his practical method to legal constitutional questions, then posed a follow-up question that moved the proceedings forward while upholding the tone of substantive engagement. Building on your framework, Representative Crockett, how would you have us articulate the standard for determining when educational disparities cross the legal constitutional threshold? This question, seeking elaboration rather than demanding core premises, reflected how Crockett's exceptional representation had shifted the dialogue from whether her framework had merit to how it might be practically applied. It represented a level of engagement typically reserved for arguments that justices find particularly compelling, regardless of their predispositions on the underlying issues. Crockett's reply continued to demonstrate the qualities Roberts had recognized. Justice Breyer, I would propose articulating the standard in terms of whether disparities effectively foreclose the basic educational opportunity necessary for meaningful exercise of other legal constitutional rights and civic participation. This would require examining both resource inputs and outcome measures through a functional, rather than formalistic lens. She then outlined specific workable criteria courts could use to apply this standard, without becoming entangled in policy judgments better left to legislative bodies. Her method recognized legitimate concerns about legal overreach while providing ethical guidance for enforcing legal constitutional guarantees, exactly the kind of balanced evaluation that earns regard across ideological lines in the legal community. As the questioning continued, justices from across the court's ideological spectrum engaged with Crockett's framework, not necessarily indicating agreement with her conclusions, but demonstrating regard for the intellectual integrity of her evaluation. Questions probed boundaries, tested implications, and explored practical applications. The kind of substantive engagement that signals in presentation is being taken seriously on its merits. Throughout this extended questioning, Crockett maintained the exceptional quality of her representation. Rather than becoming defensive when challenged or triumphant when receiving supportive questions, she engaged each inquiry with the same analytical rigor and regard for the court's organizational role. This consistent quality further confirmed Roberts's assessment of her representation. As her time concluded and the next attorney was called, something unusual happened. Several justices, including some likely to disagree with Crockett's position on the merits, made notes on her presentation, not merely to reference points they wished to address later, but to capture aspects of her analytical framework that had impressed them regardless of their predispositions on the case. In the press section, journalists who had come expecting typical ideological differences found themselves documenting something different. An instance where expert quality had been recognized across those differences, reminding observers that beneath partisan narratives about the court lies a legal institution where craft and logic still matter tremendously. What neither Roberts nor Crockett could have anticipated was how quickly word of this exchange would spread through legal circles and beyond, inspiring discussions about quality in legal logic and the capacity for expert regard to transcend partisan differences. In the days following the Supreme Court presentation, something notable began happening throughout the legal community. What might have been just another day of oral arguments was transformed by Roberts's recognition of Crockett's legal brilliance into an instance that inspired reflection about quality in legal logic and expert regard across ideological lines. The court's official transcript and audio recording were released per standard procedure. But what wasn't standard was how widely they circulated. Law professors from schools across the ideological spectrum shared the exchange with their students, not as an illustration of particular legal conclusions, but as a demonstration of exceptional representation that surpassed partisan positions. In my 30 years teaching legal constitutional law, I have rarely used Supreme Court arguments as teaching tools, noted a professor at a leading law school. But Crockett's presentation and Roberts' recognition of its quality offer something invaluable for aspiring lawyers to study, regardless of their partisan leanings or views on the specific case. Law firms similarly incorporated the presentation into expert development programs. A senior partner at a major firm explained, "What makes this exchange so valuable isn't that either Crockett or Roberts reached particular conclusions. It's that it demonstrates what truly excellent legal logic looks like. Anticipating concerns, engaging with demanding precedent, building coherent analytical frameworks. These skills transcend partisan positions and represent the highest aspirations of our profession." The impact extended beyond training future lawyers. Legal conferences and bar associations across the country incorporated discussions of the exchange into programs about quality and representation. These discussions stressed how Crockett's presentation showed key qualities that enhanced the legal process itself. Precision in framing legal questions, substantive engagement with demanding precedent, and regard for organizational roles while advocating for ethical positions. For Roberts and Crockett themselves, the public reply to their exchange was both affirming and somewhat surprising. Roberts, when asked about his comments at a legal conference weeks later, offered a characteristically balanced reflection. The court functions best when offered with the strongest possible legal logic from attorneys across the spectrum of legal constitutional viewpoints. Recognition of exceptional representation isn't about agreement with particular conclusions. It's about appreciation for the kind of rigorous evaluation that helps the court fulfill its legal constitutional function. Crockett, speaking to law students at her alma mater, similarly stressed the substance behind the exchange rather than its personal dimensions. What matters isn't that my particular presentation received recognition, but that there remains space in our legal system for substantive engagement across different legal philosophies and partisan perspectives. The law at its best has always involved this kind of engagement with ideas rather than merely with partisan positions. The most crucial impact came in how the exchange influenced discussions about the relationship between law and politics in American society. In an era when Supreme Court coverage often concentrated primarily on partisan dimensions, this instance offered influential reminder that beneath those dimensions lies a legal institution, where craft, logic, and ethical evaluation still command regard across ideological lines. Legal commentators who typically emphasize partisan narratives found themselves discussing different aspects of the court's functioning. One noted legal constitutional scholar observed, "What makes the Roberts-Crockett exchange so crucial isn't just expert courtesy between two accomplished attorneys. It's a window into how the court at its best functions not as a partisan body, but as a legal institution where rigorous logic and ethical evaluation command regard regardless of ideological alignment." 6 months after the presentation, as the legal community awaited the court's decision in Wilson, law schools across the country hosted a coordinated series of programs examining quality and legal logic across divides. These events brought together judges, practitioners, and scholars from different jurisprudential perspectives to discuss how Crockett's representation demonstrated qualities that enhance legal discourse, regardless of specific conclusions. What Representative Crockett showed in her presentation, noted a federal judge speaking at one such event, wasn't representation that would appeal only to those already aligned with her position. It was representation that commanded regard from those with very different perspectives, because it engaged substantively with their concerns, rather than dismissing or avoiding them. This emphasis on substantive engagement rather than mere persuasion of the already convinced reflected a deeper understanding of representation's role in a legal constitutional system. As a distinguished appellate attorney observed during another program, the highest form of representation isn't about scoring points or appealing to those who already share your conclusions. It's about advancing understanding of legal constitutional values and their applications through rigorous logic that respects different perspectives while upholding ethical positions. Law clerks from that Supreme Court term, speaking later with appropriate discretion, noted how the exchange had influenced discussions among the justices during their deliberations. Without revealing confidential details about the court's internal processes, several mentioned that Crockett's analytical framework became a crucial reference point in their discussions, cited by justices across the ideological spectrum, even when they disagreed about ultimate conclusions. When the court eventually issued its decision in Wilson, legal observers noted something unusual. Though the justices divided on aspects of the holding as expected given their different legal philosophies, the opinion contained sections of analytical common ground that built upon frameworks Crockett had offered. This suggested her representation had influenced the court's thinking in ways that surpassed usual ideological differences. Chief Justice Roberts's majority opinion specifically noted, "While members of this court may reach different conclusions about specific applications of equal protection values to educational funding, we recognize the exceptionally considered framework offered during oral presentation that helped clarify the legal constitutional questions at stake." This citation, unusual in its specific acknowledgement of representation's contribution to the court's evaluation, further confirmed the exceptional nature of Crockett's legal logic and its impact on the court's deliberative process. Perhaps the most lasting legacy came in how law schools incorporated the Roberts-Crockett exchange into their teaching about legal representation. Rather than focusing exclusively on winning arguments or persuasive techniques, professors began emphasizing how truly excellent representation enhances the legal process itself through rigorous logic and substantive engagement with different perspectives. A year after the presentation, a consortium of law schools announced the creation of the Quality in Legal Constitutional Representation program, designed to train future lawyers in the qualities Crockett had showed. Precision in legal logic, substantive engagement with demanding precedent, regard for organizational roles, and ethical evaluation that commanded regard across jurist-credential divides. When asked to speak at the program's launch, Crockett stressed the quality and representation served legal constitutional values beyond any particular case outcome. The legal constitutional system functions best when courts engage with the strongest possible arguments from different perspectives. Representation that facilitates this engagement, that anticipates concerns, addresses them substantively, and maintains analytical coherence, strengthens our legal constitutional democracy, regardless of specific case outcomes. Roberts, though declining formal involvement to maintain appropriate legal distance, sent a message to program participants that reflected similar values. The quality of representation directly affects the quality of legal decision-making. When attorneys present rigorous ethical evaluation that engages substantively with different perspectives, they help courts fulfill their legal constitutional function more effectively. The story of Roberts' recognition of Crockett's legal brilliance serves as an influential reminder that beneath partisan narratives about our legal institutions lies an expert community where quality and logic and ethical evaluation can still command regard across ideological lines. Their exchange showed how substantive engagement across differences strengthens not just individual cases, but the legal constitutional system itself. As we conclude this notable story, we invite you to like and subscribe for more content that celebrates moments of quality and regard in American institutions. In a media landscape that often emphasizes division, we're devoted to highlighting examples of how expert integrity and intellectual rigor can still transcend those differences. America's legal challenges remain complex, and perspectives on legal constitutional interpretation vary significantly. But the Roberts-Crockett exchange reminds us that addressing these challenges effectively requires not just representation for particular positions, but the kind of rigorous logic and substantive engagement that enhances our entire legal constitutional system. In your own expert life, consider how you might apply the lessons from this influential instance. How might you advance your values and perspectives while engaging substantively with different viewpoints? The health of our democracy depends on professionals in all fields who can combine strong convictions with the kind of intellectual integrity and regard that Roberts and Crockett showed in their notable exchange. Change.